Hello friends, good morning and welcome to EduSat Live Lectures. Dear friends, today we are going to talk about pharmaceutical patenting and public health with a special focus on compulsory licensing in India. To discuss this topic, we have with us our subject expert Dr. Ashwini Siwal. Dr. Siwal is Assistant Professor in Faculty of Law, University of Delhi. Without further ado, I would like to welcome sir to our studios and request him to start the lecture. Welcome sir.
Thank you very much, Amrit. Well, good morning, viewers. See, as Amrit rightly mentioned, that our discourse would be on the compulsory licensing regime in India. But see, as she highlighted in her introduction, that we have in our previous discussion talked about pharmaceutical patenting in India. Well, friends, I would like to take 2-3 minutes time to recapitulate as to what I discussed in my previous discourse. Friends, pharmaceutical patenting is the one of the most important talked about and one of the most important in terms of getting the benefit to the public in India, because India is a populous country. Especially, India is being looked at as a generic hub nation, wherein many generic companies, pharmaceutical generic companies, are producing generic drugs, making the generic drugs available to the world at large, because it has been considered as a hub of whole nation, pharmacy for the whole world. Well, friends, in my previous discourse, I talked about one case study. It was Novartis versus Union of India, wherein I discussed elaborately about the issue in question in that case law. I mean, the specific variation on which Novartis was seeking patent protection in India. So, see, with that note and with my belief that you understood my previous discourse properly and comprehensively, I would like to take you to another important area that is also related to pharmaceutical patenting in India. Well, friends, we learn pharmaceutical patenting and we see pharmaceutical patenting from the point of view of the individual interest and from the point of view of the interest of the masses at large. So, see, in my last discourse, I told you as to how the officials or the incumbents in patent office, as well as in the intellectual property appellate board and judges sitting in the High Court and Supreme Court, delivered a very beautiful judgment upholding the law of the land and keeping in mind the interest of the masses, as well as taking care of the law, black written law, I mean the way it is written in the by the legislature in the Indian Patents Act 1970. See, when it comes to pharmaceutical patenting, as I told, that it percolates benefits only when the drug is available, when the drug is accessible and is available at an affordable price. Otherwise, it would be really difficult to gain the benefit of the pharma invention or pharma innovation. So, one more, the tool in the hands of the patent controller or say in the Indian Patents Act 1970 available to the patent controller in terms of making the pharma invention or pharma innovation accessible to the masses at large. That is compulsory licensing. I mean, in the previous discourse, I told you that as to what happened in the Novartis study, in the Novartis case, wherein the Supreme Court, the apex court of the country, decided in favor of Union of India instead of deciding in favor of the applicant Novartis. But that is how, I mean, the balance was maintained by the Supreme Court to percolate the benefits and trickle down the benefits of the drug invention to the masses. Another tool that is really one of the important tool in terms of making the drug accessible and making any invention or any technology, patented technology, available to the people is compulsory licensing. So, my today's discourse, friends, would revolve in two propositions, in two trajectories. In my first session, I would like to discuss some of the important provisions catering or talking about pharmaceutical compulsory licensing, or say compulsory licensing to any technological thing or a patented technology. Another half I would devote in picking up a case study in India, the only available case study as far as compulsory licensing of a drug is concerned in India, and that is of a recent past. In 2012 only, we had a case law where in the case of Bayer versus Natco, friends, the patent compulsory license was granted to the Indian generic company, Well, let us first have a look at what is the regime or the law relating to compulsory licensing in India. So in this session where I will be talking about the regime relating to compulsory licensing in India, I would highlight my discussion only on those provisions of the law which talks about the compulsory licensing and comprehensively tells and encompasses in their sweep as to in what situations a compulsory license can be granted and who can grant it, who can apply to obtain a compulsory license. So before understanding the provisions and the matrix of the provisions available with us in the Indian Patents Act, I would like to tell you that there lies a provision in the Indian Patents Act of voluntary licensing to any interested person. And that voluntary license, if takes place, then there does not arise a question of compulsory license, because there is no need of licensing the technology compulsorily. It is only when the manufacturer, the patent owner, the technology holder obstructs others from obtaining the voluntary license and making the drug available, making the invention available to the people. There comes a question of compulsory licensing. Otherwise, one can easily cater the need of the people and the society, no matter, notwithstanding that India is a populous country, with the help of the voluntary licensing regime available. Because in the case of the voluntary licensing, the license takes place voluntarily without any kind of obstruction and impediment posed by the owner of the patent, and it goes straight away. The benefits of it, the fruits of it, are reaped by the masses at large. So see, let us have and compare the regime of the voluntary license on the one hand and the compulsory licensing on the other, one by one. In case of a voluntary license, friends, you see, the voluntary license, as I mentioned, can be granted by patentee to multiple generic companies. It can be granted to multiple people. So it's kind of a transfer that is taking place of our intellectual property, the way there takes place a transfer of any property. For that matter, a desk is being transferred to another person, or a land occupied by one person having a title over that is being transferred to any other person. In the similar manner, there can take place a transfer of the intellectual property, and especially in the case of the patents, where the stakes are very high, the property is very lucrative, because people look at the intellectual property, especially patents, with a view of milking more money and minting more money. Well, a voluntary license can be granted, as I said, to multiple generic companies, so that they can trickle down the benefits of their license obtained from the patent holder to the masses. Another feature in the cap of voluntary licensing regime, that these generic companies, those who are the licensees in this case, as they have obtained the license, a transfer in the form of license, they can generate revenue and start manufacturing drug, and they have to pay royalty to the concerned patent owner in lieu of making that, in lieu of manufacturing these drugs. Well, if we go ahead, we see that they actually make the drug affordable and available to the people, because see, as the generic companies are coming up with the generic versions, and these versions of the generic companies are not patented, and that is why it is very convenient for them to make it accessible and to keep the affordable price for the masses, for the people who wants to access, especially patients. Well, this is one of the most important aspect where voluntary regime works out perfectly and properly. Another thing, that they make the drug accessible, and the innovator company percolates the benefits to the public through generic companies. So the innovator company who initially obtains a patent, they are serving the people through the generic companies. As such, they are not having any facilities to manufacture or any plans to manufacture the patented drugs. So in that case, they do, license it, transfer the technology, transfer the pharma innovation and invention to the generic company, which is a licensee in this case, and the licensee percolates the benefit to the people. So if we have a look at all the features of voluntary licensing regime, I believe, and it is easily understood that it can be easily made out that this regime percolates the benefit in a proper manner, makes the drug affordable, does not keep the price at an exorbitant rate, and that is how the voluntary regime is like the regime is a regime which is always close to the masses, is always functioning for the people at large, not only catering the individual interest of the patent holder. Well, if we see the diametrically opposite regime available with us, wherein we have a compulsory regime available, and that compulsory regime, as the name suggests, has is kind of a compulsion to be made on the patent owner or on the patent holder to license the property, to license the pharma innovation or invention to the licensee if he demands. And sometimes if nobody demands it, still the central government does have certain powers. Special provision is available in the form of 92 and 92A, where the central government itself can ask the patent owner, the owner of the pharma innovation, the patent holder I mean, to do the compulsory license of that particular property to some generic company, so that the benefits of it can be given or distributed to the masses, disseminated to the masses. Well, see, as I told that, as the name suggests, in the case of the compulsory in the case of the compulsory licensing, it's quite tough to strike a balance, because innovator does not want to allow anybody to interfere in his regime, because if somebody will try to trespass your property, undoubtedly you will try to restrict that person. And that is how the innovator, who thinks that it is his monopoly and it is his exclusivity that lies on that particular technology or on that particular pharma innovation and invention, so he won't allow anybody, or he won't feel happy if somebody tries to impinge and intrude into his property by way of making it compulsorily available to the people. But it is the need of the hour, and it is the need of the nation, and it is as envisaged in many of the international conventions that public health and medicines availability is the pivotal question, and it has to be addressed at any cost, no matter that the owner of the patent gets jeopardized or his interest gets jeopardized. Because see, in these cases, law plays a proactive role, where the law strikes a balance between the individual right and the right of the masses at large. And any law for that matter, friends, it's not only in the case of the intellectual property law that this kind of a balancing is required, this kind of a weighing is required. If you want to take examples, you can take examples of the criminal law, you can take examples of other laws available in our country, where every time the law strives to strike a balance between the individual right and the right of the public. Every individual does a right not to be, see, if we take an example of the criminal law, every individual does have a right not to be harmed. Equally, other individuals does have a right not to be harmed. So on the one hand, I mean, he has been granted a right not to be harmed. On the other hand, he has been imposed with a duty not to harm others. So that is how the law has struck the balance in the intellectual property law, especially in the Patents Act 1970, by incorporating compulsory licensing regime to check the abuse of intellectual property. Because if somebody denies to do the voluntary license, in that case, the law will not want to be or would not want to be a mook spectator. The law wants to function in that situation, in that kind of a vacuum situation, and the law does what? It incorporates certain provisions which are making it a compulsion to the innovator to license the innovated technology or the innovation to the generic company. Let us see what are the features and the specifications of the compulsory licensing regime one by one, in contrast with the voluntary licensing regime. See, in case of the compulsory licensing regime, if you see, it is granted in compliance with the government stipulated grounds, and the grounds which are stipulated by the government, they are getting manifested and demonstrated in the Patents Act 1970, which is a domestic legislation in India. All the grounds which makes compulsory licensing easier are available as per the government stipulations in the Patents Act 1970. Then it grants to address the scarcity of drugs. Undoubtedly, it is granted to address the scarcity of drugs, to make the medicines available, because law has to take care what the Doha Declaration post TRIPS in 2001 declared. A very important declaration came out from the Doha Declaration in 2001, wherein they upheld the question of medicines availability, upheld the question of drugs availability, to protect the public health, and preserve the public health. So in light of that background, if one sees, then we find that our law, while incorporating compulsory licensing provisions, is in consonance, is in compliance with what Doha Declaration and previously in 1995 TRIPS spoke and envisaged. Well, the next feature of the compulsory licensing, friends, It is granted to address no availability and affordability of drugs or unaffordability of the drugs, sorry. Another thing is that it is granted in case of national emergency. I mean, one of the grounds or one of the cause where the compulsory license can be granted in a case of national emergency, and especially you see the central government enjoys these powers to ask the controller concerned to grant a compulsory license of the pharma innovation in case the pharma innovation is not available, is not accessible at an affordable price, and especially when there is a situation of epidemic and endemic like AIDS and like tuberculosis situations, malaria situations. In those situations which are the crucial crisis situations of national emergency, the central government does have a power to instruct the controller concerned to go for the compulsory licensing of the drug available. Well, that is how we can make out the difference and the contrast in the voluntary licensing regime and on the other hand, which is a diametrically opposite regime of compulsory licensing. And as I told, that compulsory licensing regime is primarily made for the purpose of checking the abuse of the intellectual property, because when a person obtains it, he ensures that he will make the invention workable. When he gets the patent protection, it is his mandate to make it available at an affordable price. So there should be certain provisions which keeps the enforcement part intact, and that is why the compulsory licensing regime has been incorporated to look at the enforcement of the promise which the person makes to make the invention, technology or any kind of a pharma innovation workable and accessible to the people. Let us move ahead and see the concrete provisions and threadbarely analyze the provisions given in our domestic legislation, Patents Act 1970 one by one. Well, friends, as I have discussed the international instruments, one instrument which is missing and I missed to speak is the Paris Convention. Article 5A of the Paris Convention, friends, strives to strike a balance by mentioning that each contracting nation has a right to take legislative measure for the grant of compulsory license. Every contracting nation, every signatory nation has been empowered to take legislative measure for the grant of compulsory license. So India, taking a cue from this 1883 Paris Convention, as we are the signatory of Paris Convention 1883, we do have this flexibility to incorporate some compulsory licensing provisions in our domestic legislation, and that is why we have incorporated to make the drugs available, especially to strike a balance, that balance which makes the drugs available, not only looking at the monopoly or not only upholding the monopoly, rather taking care of the interest of the masses at large in toto. Another thing is that Article 31 of the TRIPS does not categorically speaks about compulsory licensing regime as such, but it talks about other use without authorization. I mean, it allows that some use can be made of the patented work, patented technology without the authorization. So what do we infer from this Article 31 of the TRIPS is quite clear, that in case of emergency, in case of scarcity, in case where the drug is required to be made accessible, it can be done. I mean, the use without the authorization of the owner of the patent can be done, can be made, and that is how the drug can be made available. These are the international instruments as far as compulsory licensing provisions and the law relating to compulsory licensing in India is concerned, from where we draw the backing as actually the next part, friends, where we have to see the legal provisions for compulsory licensing in India. Under Indian domestic legislation, we have Indian Patents Act 1970, and it has got three provisions specifically, explicitly talking about the compulsory licensing. One is Section 84 of the Act, another is Section 92, and the last one, friends, is 92A. So see, these three provisions and the whole axis of compulsory licensing regime revolves on these three provisions. These are the axis, these are the primary provisions discussing, talking and reading about the law relating to compulsory licensing in India. Section 84, friends, talks in a general sense about the compulsory licensing as to when and after what period any interested person can apply for the compulsory licensing. In the case of Section 92, friends, it's a special provision available at the disposal of the government, central government, to go for the compulsory licensing of drugs in certain situations enumerated there under in section 92 itself, that we will see later in my later discourse. And in section 92A, if you see, there is another power or special provision available at the disposal of the government to export the innovation or pharma innovation to meet the requirement of another nation in need, if that nation is also ready to reciprocate. Fine. Well, let us see the sections relating to compulsory licensing one by one in a very exhaustive and threadbare manner. If you look at section 84, friends, the language is quite clear as it reads that at any time after the expiration of 3 years, what is noticeable here, that any person if is willing to go for a requirement of any license, a compulsory license I mean, he has to wait for 3 years. If during those 3 years the patent holder, the owner of the patent, does not make it workable, does not make it affordable and accessible to the public in India, then after 3 years of the cessation, after cessation of the 3 years I mean, one can apply for the compulsory licensing, and that person should be the person interested. I mean, now we have to ponder over as to who would be called a person interested, because it is really tricky to know from the language, from the superficial language of the provision, from the apparent language of the provision, as to who would be called a person interested. So here we have certain case laws to decipher what is the meaning of the person interested, and from there only we will come to know about who constitutes the person interested. But for superficial understanding, I can tell you right now in one line that any person who shows the capacity and the ability to make the drug available, accessible, affordable, he can be called a person interested, and he has to wait for 3 years time period before getting eligible to be called a person interested, and then to apply for the patent protection, I mean to apply for the compulsory licensing, sorry. Well, if you go ahead with the language further, it reads that at any time after the expiration of 3 years from the date of the grant of a patent, any person interested may make an application to the controller for grant of compulsory license. And then it reads that the person that the reasonable requirements of the public with respect to the patented invention have not been satisfied. These are the 3 situations enumerated under section 84, where a person after the cessation of 3 years of time period after the grant of the patent can make an application to the controller for the grant of compulsory license. The very first situation when he can do so is the situation when the reasonable requirements of the public with respect to the patented invention have not been satisfied. So friends, I believe that you can easily make out as to what would be the meaning of reasonable requirement or the satisfaction of the reasonable requirement. In the context of the pharma innovation and pharma invention, satisfaction in terms of reasonable requirement, meeting the reasonable requirement of the public means making the drug accessible, making the drug affordable, making it available at the counters across the country. If that kind of a reasonable requirement has been met, there is no question that arises for obtaining it compulsorily. But if that reasonable requirement has not been met, in that case it becomes a very solid ground, a cogent ground for the person interested after the cessation of 3 years of time period after the grant of the patent to apply for the compulsory license to the controller concerned. Another ground, if you look, is the ground in the form of if the drug is not available to the public at a reasonably affordable price. So again, you see, it seems that these 2 grounds are similar, but see, in totality or in a wider ambit, if you look at these 2 grounds, in a wider proposition, if you look at these 2 grounds, they are 2 different grounds, but having some sort of a similarity, and they are incorporated as such because the law does not want to leave any kind of a stone unfold, so that they can easily make the person interested eligible to get to make the controller request for compulsory license to be granted to him, even in the case if the drug is not available to the public at a reasonable affordable price. And meeting the reasonable requirement, making the drug available at an affordable price seems similar, or are kind of a similar, are complementary, are interrelated. The third requirement is the requirement in the form where that the drug is not worked in the territory of India, where the patented invention is not worked in the territory of India. So what does it mean? working hairs, let me take a pause to tell you as to what is the meaning of work or working of the patent. Well friends, as I have discussed previously in my earlier discourses, when we talked about procedural aspects for obtaining a patent, that when a person applies for a patent, he has to show the utility of the patent, and by fulfilling the requirement of utility, he shows that his work or his invention is workable and will work later on, and it can be applied industrially. So if any manufacturer who comes to India and obtains a patent protection on a pharma innovation, if it does not make certain facilities in India, facilities here means does not situate certain plants in India for manufacturing of that particular invented drug or on that particular patented drug, and he does not make it workable in an industry, then he gets disqualified. I mean, his promise made in the beginning while applying for obtaining the patent was a facade, was kind of a false promise made by him. So that is how the workability, the working of the patented invention is checked later or even after getting the patent. Even for the 3 subsequent years it is checked that whether the patented technology is working or not, is workable or not, is available at an affordable price or not, is accessible to the people or not, and then it is to be seen whether it is meeting the reasonable requirements of the public or not. Here reasonable means it should come into a reasonable price, it should be reasonably available. Well, if we go ahead with another provision of section 84 itself, where some of the factors are given and provided to be considered by the controller while granting the compulsory license to the person. These are certain factors, friends, which are to be kept in mind, especially by the controller while granting the patent. What is the nature of the invention? He has to see as to what is the nature of the invention. If it is such an invention which is not necessary and which is not kind of a required to be made available to the people, then obviously he will not at all grant compulsory license for that. But if it is a medicine, and if it is a essential medicine, essential drug to be made available to the patient suffering from diseases, ailments, then in that case the nature of invention is such which requires some sort of interference by the controller. The another factor to be taken into consideration by the controller as it pertains to the time which has elapsed since the sealing of the patent, since the grant of the patent, as to how much time has elapsed. As I have shown you and I made it noticeable that section 84 in the very first sentence tells that after the expiry of 3 years only it can be made available. So it is quite clear that he has to see, I mean the controller while granting whether the particular patent can be made a compulsory license or can be made available by a compulsory license, he has to see the time elapsed. If it is less than 3 years, the section 84 will not get invoked. In that situation, some other provisions are available which are special provisions in that light or in that regard, but section 84 and its applicability, its invocation will be highly questionable, because 84 cannot be invoked in that situation where 3 years has not elapsed. So section 84 comes into picture only when 3 years have already ceased, has already passed. The another factor that is to be considered by the controller is the measure already taken by the patentee or any licensee to make full use of the invention. Well, friends, let me tell you that this is very crucial for the controller to see and to check whether the person who is seeking the patent protection, he has tried or not to obtain the voluntary license. If he has tried to obtain the voluntary license, then it's fine. I mean, if he has been refused by the patent owner, or if the patent owner tries to impose certain unfair, non-discriminatory terms into an agreement, in those situations he can come to the controller, and the controller should have to see whether there was some sort of attempt made by the person interested for obtaining it voluntarily. Well friends, we'll continue with this discussion in my next session. I'll meet you in the next session. Thank you so very much. Welcome friends to the next session. Well, we have to discuss the factors to be taken into consideration by controller while granting a compulsory license. As in my previous session I discussed about the law relating to compulsory licensing in India, and especially section 84 we were discussing. So we are in the halfway of discussion as far as section 84 is concerned, which is a very crucial provision of compulsory license and which makes it easy for a person interested to obtain a compulsory license from the patent controller. Well, the factors which are very crucial to be taken into consideration by the controller are as follows, friends. Section 84(6) summarizes them in an unequivocal manner, in an unambiguous manner. The very first factor that has to be taken into consideration is the nature of the invention. Well, friends, as I told you in my previous session, that the controller will always look at as to what is the nature of the invention. If he finds the nature of the invention is such where there is no need of making it available compulsorily or by making it a compulsory license, then he won't go for or go ahead with the compulsory license. He won't give a compulsory license to the person interested. But see, there are certain other factors also to be taken into consideration. Let us see the next factor, which is very crucial to be taken into consideration. So see, as we have seen from the language of section 84(1), that only after the expiry of 3 years, the patent controller can make the patented technology available by way of compulsory license, or he can grant the compulsory license only after the expiration of 3 years, and especially in the case of 84, I mean. In other cases, in the case of 92 and 92A, he can do so, but in the case of 84, he can never ever grant a compulsory license, or he cannot go for a compulsory license without expiry of the 3 years of time period. And a person interested should also be take care into his mind that 3 years have already passed as far as this particular patent is concerned. It has not worked for 3 years, it has not met the reasonable requirements of the public, and 3 years have already been passed. In that case situation, after the 3 years of the cessation or after the expiry of the 3 years from the grant of the patent, the interested person can apply for the patent, and this factor is a very crucial factor to be taken into consideration by the controller in this case. Another factor to be considered by the controller, friends, that the patentee or any licensee, whether the patentee or the licensee did try to make full use of the invention. If he has already made full use of the invention or has taken certain measures already to make the full use of the invention, then in that case the controller may hesitate or will hesitate in going ahead with the compulsory license, because he thinks that the inventor, the owner of the patent on pharma innovation, on pharma drug, has already taken certain measures to use it fully, to make its full use. So in that case, it looks as if he has tried his best and he has taken certain measures which are due measures to be taken by any owner of the patent after obtainment of the patent to make it available to fully use the invention. If he has done so, in that case the controller will hesitate to go ahead with the compulsory license application, and he will reject the application of the applicant for granting the compulsory license on a patented invention which has already been fully evolved, fully used by, or some measures have been taken by the patentee in a full-fledged manner. The next thing or a next factor to be taken into consideration by the controller is to see the ability of the applicant to work the invention to the public advantage. If he finds that the controller finds that the patentee or any licensee of the patentee does have the ability to work the invention to the public advantage, if he thinks that he or she, or I mean the entity which has been granted the patent protection on that pharma innovation, if they have the ability to work the invention to the public advantage, then in that case the controller will be little hesitant in going ahead with the compulsory license, in disposing the compulsory license application in favor of the applicant of the compulsory license. Or you can say that these are the factors to be taken into consideration by the controller. So what are the factors? If you summarize or sum up in 1 minute time, the very first factor is to see the nature of the invention, and to see what time has elapsed after the grant of the patent, what measures have already been taken by the patentee or by the licensee to make the full advantage or make full use of the invention. And the last but not the least is the ability of the applicant to work on the invention for the public advantage, not for his own personal advantage, not for his own personal benefit. Well, some of the more factors available with us to be seen or to be scrutinized by the controller at the time of disposing the application for the compulsory license, to see the capacity of the applicant. Well, this is very crucial, friends, and very interesting too. See, the applicant, one who approaches the controller for obtaining a patent, he boasts about his capacity, he projects his capacity to work on that invention, but sometimes it is sheer absurd claim or kind of a nonsensical claim made by the applicant that he will be able to work on that particular technology. He may be a rival or a competitor entity or a competitor company, may be trying or attempting or striving to snatch the patented technology from the patent owner and goes ahead with the compulsory license application. So their capacity has to be checked. If they are capacitated enough to work on the invention, if they have the resources to work on the invention and to undertake the risk in providing capital and working the invention, then the application may be granted, compulsory license may be granted. Otherwise, there does not arise any question of granting a compulsory license of a patented technology to a weak entity, to an entity which does not have the ability and the capacity to undertake certain investment and risk associated in that investment, because even they won't be able to work on that invention, even they won't be available to make it available. So ultimate aim, the resultant aim of controller is to make the drug available, make the pharma invention available through the compulsory license regime. So this factor is one of the very good prerequisite to be seen and sine qua non to be seen by the controller, the capacity and the ability of the applicant, not of the patentee or the licensee in that case. Another factor to be seen or checked, gauged by the controller at the time of considering the compulsory license application is as to whether the applicant has made efforts to obtain a license from the patentee or reasonable terms and conditions, and such efforts have not been successful within a reasonable period as the controller may deem fit. Well, friends, if we elaborate it later, we find that if the applicant does make certain efforts, and on previous occasions prior to filing application for obtaining a compulsory license, if on the previous occasions, if there is a record when he has on previous occasions applied for obtaining a voluntary license from the patent owner, and the patent owner did not grant him, did not license or transfer him the patented technology, because the patent owner wanted to put certain non-discriminatory, unfair, unreasonable conditions while granting it, or maybe refusing at all, completely outrightly refusing not to give it to the applicant. So it has to be checked whether the applicant has made certain efforts, has endeavored to obtain the technology. Only then he is allowed to come with the compulsory license application. If on the previous occasions he was found sitting dormant, he was not doing anything, he was not making efforts or endeavoring to get or fetch the patented technology through the voluntary license, then there does not arise any question of granting him a compulsory license of that particular technology. Well, now jumping to the special provisions, as we are over with the threadbare discussion of section 84, friends, and its crucial clauses, we have to see what are the special provisions available for the compulsory license in Patents Act 1970. If you have a look of Indian Patents Act 1970, we have section 92 which categorically or explicitly tells about the special provision available to the central government to go for the compulsory license of any pharma innovation, pharma invention, or any kind of a technology for that matter, which is a necessity for the government or which is necessary for the government to make that particular drug available in that extreme urgent situation, in that national emergency situation, in the crisis, in the endemic. Let us see that provision in a verbatim manner. If you look at the language of section 92, friends, as appeared on your slide, it says and it reads that if the central government is satisfied that it is a circumstance of national emergency or a circumstance of extreme urgency. Here, see, there is a difference between these two clauses. One is a situation of national emergency, one is a situation or a circumstance of extreme urgency. It may be extreme urgency of one particular region or of one particular state for that matter, or a territory for that matter. But in the case of national emergency, the whole nation is having or facing the scarcity or kind of emergency in terms of availability of the drug. And the third situation is a case of public non-commercial use. And the third situation or the third factor, third ground available to the central government is very wide in terms of its ambit and gamut, because the government can prove that the drug, that the patented technology is available, but its availability is a commercial use only. It's not a non-commercial use. It has to be always a non-commercial use to be proved that the patent was working, it was being utilized, it was applied industrially, but it was not working properly, it was working for a commercial use, not for a non-commercial use. So it has to be checked whether it is a case of public non-commercial use. And what does public non-commercial use connote? It connotes that the public is not getting it available at an affordable and accessible price. The drug is in use, the technology is in use, the pharma invention is in use, but that use is a purely commercial use done by the patent owner, by the licensee of the patent owner, for their own monetary gains, for their own benefits. It is not a public non-commercial use that they are trying to get or make available to the people. Well, another aspect to be looked as far as section 92 and its language is concerned. See, if the central government is satisfied under these situations given available, which may arise or is required as the case may be, including public health crisis, if there is a circumstance of national emergency, including public health crisis relating to acquired immunodeficiency syndrome, human immunodeficiency virus, tuberculosis, malaria and other epidemics, or a circumstance of extreme urgency where there lies a public health crisis, or a case of public non-commercial use, in any of the following situations given here under, the central government does have a power, and by invoking the powers provided under section 92 to the central government, the central government can direct the controller concerned for granting a compulsory license to the reasonable applicant, or in that case, if it is a case where no applicant is there, then to any entity having the ability and capacity to make use or make full use of that particular invention or a pharma innovation. So these are some of the grounds. Well, friends, I would like to pause here for a moment for a discussion that see, as far as these grounds are concerned, in India in recent past there had not arisen any instance or occasion where the central government has exercised these powers. And if you see the matrix, and if you see the Indian situation, especially the Indian population and the need of the population, we can say that there had arisen certain occasions, on many occasions, or on many in many instances it was kind of incumbent for the government to take certain measures to exercise these powers, but government did not do. Government lost the opportunity to exercise or invoke section 92. Instead, government tried to control the drug pricing from other measures instead of invoking Patent Act 1970, or instead of exercising the power provided under section 92, which I believe is a failure on the part of the government, because the government should have exercised and tried to at least exercise this power given under section 92 to make the things available to the public at an affordable price. Well, if I would like to kind of trace one occasion where India suffered, it was a great famine of Bengal, where there were epidemic relating to many diseases or epidemic of the diseases, the government did not exercise this power. This power though is available under the Patents Act, which is of year 1970. So they should have exercised it. On many occasions, I mean, they should have exercised it, but they failed to do so because they never took this particular power into consideration, as the government had certain other measures, and India as such is a generic hub for a pharmacy of the whole world at large. So they have kind of managed to circulate, or maybe kind of on papers managed to show that they have met the requirements of the public by making the drugs available even in the situations of extreme urgency and national emergency. Well friends, going ahead with another provision or another power of the central government, and the government should try to invoke these powers in situations of extreme urgency, national emergency, in situations where the work is available but it is made available or is being used only for the commercial purpose, not for non-commercial purpose. The next provision that categorically and explicitly talks about the powers provided to central government is 92A. Let us have a look at 92A, friends. If you see the language, it reads that compulsory license shall be available for manufacture and export of patented pharmaceutical products to any country. Well, kindly read it again. It's very crucial to understand the nuances of section 92A. It says that compulsory license shall be available for manufacture and export of patented pharmaceutical products to any country having insufficient or no manufacturing capacity in the pharmaceutical sector for the concerned product to address public health problems, provided compulsory license has been granted by such country, or such country has by notification or otherwise allowed importation of the patented pharmaceutical products from India. Well, friends, I recall one incident, or one very celebrated incident in India, where the Indian drug manufacturer Cipla came up with offering to West and offering to the South Africa and nations where there was prevalence of human immunodeficiency virus, or many patients were affected by HIV. In that incident, the Cipla, which is the generic company in India, it offered to make the drug available to all the nations at a very cheaper cost, and that was the first instance from where the whole debate about availability of the medicines, the debate about accessibility of the medicines and an affordable price heralded. From there onwards, there had been so many conventions and meetings, congregations, where the international fraternity at large has pondered over the issue of making the drugs available, making the drugs accessible, because very prosperous nation like US had denied to the citizens of US the availability of the drugs at an affordable price, and there went a big movement against the US pharma regime, especially the lobbying of the pharma companies done in the US along with the government in question at that point of a time was really bad in terms of its implication on the patients suffering from HIV, tuberculosis and other diseases. In that situation of extreme urgency and emergency, India lended its helping hand to that nation as well as to many other nations to make the drug available at an affordable price. And from there onwards, the debate relating to making the drugs available is going on and still is persisting, has not seen the day of the light, because even today if you see, there are many nations in the world where drugs are unavailable, where the drugs are not available at an affordable price. The way in India, if you see, which is called a pharmacy of the nation, even in India we have encountered this kind of a problem on several occasions, where the drugs for leukemia, where the drugs for kidney cancer, where the drugs for other serious ailments, life-threatening diseases were not available to the people, were not made available to the people. So that is how see the whole pharma industry is trying to monopolize the drug industry and drugs and their prices. though there exists some price controlling authorities in the respective nations at the domestic level, but those price controlling authorities does not as such make any kind of a celebrated mark in terms of making the drug available to the people. So in that kind of a situation, we have section 92 at our disposal given under the Patents Act 1970, which speaks clearly that a compulsory license shall be made available or can be granted by the central government for the manufacturing and for the export of a patented pharmaceutical product or any kind of a patented technology to all the other nations, or especially those nations where they have insufficient manufacturing capacity, where they have very weak pharmaceutical sector, and where they are troubling or confronting with the issues of public health, with the issues of unavailability of the drug. As given by me in the form of an example, in the form of an instance of South Africa, or especially of the many nations in the West where we supplied them the drugs at an affordable price. So this kind of a section really helps us out in coming up with a compulsory license of any patented technology of any nation for that matter, if we feel that some other nation who is ready to reciprocate with us does not have the facilities available in that respective nation to manufacture the drug. So we can export them by making any entity by making the compulsion on any entity to license it to a generic industry, and the generic industry will subsequently eventually supply it to that particular nation having insufficient resources, nation facing or confronting the trouble in making the drugs available in that particular nation. Well friends, a very important thing is coming to my mind, a very interesting documentary which I would like to recommend to all of my viewers and audience, which I believe is a comprehensive documentary on pharma patenting, and a comprehensive documentary on patenting issues pertaining to drug innovations and inventions. Its name is Fire in the Blood, and this documentary beautifully demonstrates as to how the pharma lobby worked in US to kind of pressurize the US government in granting them the patents, and then subsequently as a corollary the US the government came under the pressure of the pharma lobby, because pharma lobby is kind of revenue generation lobby for the government. That lobby pressurized the US government, and as a corollary US government made the patents available to whole US pharma lobby or pharmaceutical companies, which eventually did what? Turned into a huge nightmare for the citizens of the US, for the patients suffering from crucial life-threatening diseases like cancer, like AIDS, HIV in US. So this documentary which I have just recommended to you, Fire in the Blood, is a must-seen documentary by all the viewers who have interest in knowing more, in learning more about the patenting, and especially the pharmaceutical patenting, especially the concept of compulsory licensing, and India's role in lending the helping hand to the whole world at large, world across. So that has been beautifully demonstrated and shown in that particular documentary, which I believe everyone would watch. Well, let's move ahead and then summarize and sum up with our today's discourse, today's session. Well friends, I would like to recapitulate in 2-3 points as to what all we have covered in today's discussion. The three things that are primarily covered by me here in this presentation. One, what are the international instruments available talking about the compulsory licensing? Another second thing which is important is the domestic provisions, or say provisions talking or relating to compulsory licensing in India in the Patents Act, which is a domestic legislation in India, that is section 84, 92 and 92A. 84 and 92 and 92A are different because 84 is available only to an interested person only after the expiration of 3 years, but on the other hand, in the case of 92 and 92A, which are the special provisions, there is no such cap of cessation of 3 years or expiry of 3 years in invoking section 92 and 92A for licensing anything compulsorily and the central government derives certain powers by purview of section 92 and 92A as far as this matrix of provisions are concerned. And the third thing that I would be discussing with you is the case study on compulsory license, the only available case study in India of year 2012. It is Bayer versus Natco, where a compulsory license, a very first compulsory license was granted by the patent controller in India and later on upheld by the Intellectual Property Appellate Board, upheld by the Bombay High Court and later on by the apex court of the country. After that, 2 more applications for compulsory license has been filed before the controller of the patent, but they had been rejected. Our latest one is on the drug Sexagliptin, which has been rejected by the patent controller to be granted a compulsory license. This we will discuss in a very exhaustive and elaborate manner in my next session, friends. And here I rest. Thank you so very much. Have a very good day.
Okay, sir. I just want to have a very quick question for
Yeah.
you. In terms of compulsory licensing, what is the importance of Doha round of TRIPS?
Well, see, Amrit, you have asked a very pertinent question. See, as far as Doha Round and its declaration is concerned, this declaration specifically focuses on the issue of protecting the public health, and it specifically and explicitly tells that availability of the medicines has to be always given utmost importance, and for that matter, somebody's individual interest or somebody's interest in terms of a patent can be sidelined. So the importance to the public health, importance to the availability of the medicines was the noticeable aspect of the Doha Declaration. No matter, notwithstanding that somebody's individual interest is getting jeopardized, somebody's individual interest is getting sidelined. So if we take a cue from Doha Declaration, we get an idea that the domestic legislation, or while enacting a domestic legislation, any nation for that matter, by taking cue from the Doha Declaration, who is a signatory of the TRIPS, can come out with such a legislation or a law which makes the public health and availability of the medicines their prime importance, or questions of prime importance, sidelining the individual interest in the form of a monopoly to be granted to a person, which is a patent in this case.
Okay, on that note, I would like to thank sir for this very enlightening lecture, and I would like to thank you, dear friends, for watching our show. Stay tuned and keep watching. Thank you.